Good morning. My name is Jonathan Ingber. I am in my, if you will, my Solomonesque office in the home in the city of Weston. Today we're going to spend a little time, not a lot of time, but a little time discussing the interplay between employment law and the coronavirus. The employment law typically, not always, deals with discrimination. In the Fair Labor Standards Act, it doesn't really deal with discrimination, but in most of the other pieces of legislation, discrimination is an issue. This virus, in terms of attacking human beings, is quite indiscriminate, if you will. Certainly, the employer does have a responsibility, particularly under some state laws, California being a shining example, to provide the employee with a safe environment. So the question is, can an employer, fearful of contagion, can he require an employee to have his temperature taken, or undergo a medical examination, or answer such questions as, do you have the kind of disability as it relates to a lessened type of immunity against this type of disease? And the answer is no, you can't do that unless it is directly related as a job necessity. Now, the Equal Employment Opportunity Commission in 2009, in response to the H1N1 pandemic, did come out with a technical document trying to explain to employers what their responsibilities are as it relates to the American Disabilities with Employment Act. So I think what I'd like to do, if I can, and I've got a couple of questions here, and the first one I would direct toward this legislation, that is the Americans with Disabilities Act. That technical document, by the way, and it runs quite a few pages, 10 to 12 pages, it deals with issues before, during, and after the pandemic. So the question might be, before a pandemic, may an employer, subject to the American with Disabilities Act, ask a worker to disclose whether she possesses a compromised immune system or a chronic health condition that the Center for Disease Control believes could make her more susceptible to medical complications from influenza. And if this is before the pandemic, the answer is absolutely not. Such an inquiry is likely to disclose the existence of a disability. By the way, the normal American influenza, it's not American really, the influenza that we take vaccines for, this is not considered a type of condition that is a disability. You can certainly ask the employee where he's traveled lately, whether in fact he's been exposed to individuals that have shown symptoms of this virus. Now, during a pandemic, when an employee returns from travel, may an employer make inquiries about exposure to pandemic influenza during that excursion, even though the employee has not developed influenza flu symptoms? And the answer is most affirmatively yes, because we're during a pandemic. This would not be considered a disability-related question, as the Center for Disease Control recommends that employees returning from specified locations remain at home for several days, conceivably 2 weeks, to ensure that they do not exhibit pandemic influenza symptoms. As you know, that piece of legislation, the American with Disabilities Act of 1990, enacted during the first and only administration of George Bush the Elder, is only one of many different kinds of statutory items that affect the employment arena. The one coming up, is the Fair Labor Standards Act that was enacted by the New Deal under President Franklin Delano Roosevelt, has been with us since 1938. And we're concerned about minimum wages. We're also concerned about overtime pay. And there's a distinction between exempt and non-exempt employees. So again, we have two of conceivably many questions that might concern this piece of legislation. So for example, in the case of business foreclosures, employers are required to pay non-exempt employees. Those are not the administrators. They're not the executives. They're not the professionals. Only for hours actually worked, not for the hours that employees would have worked if the employer's business had not closed. For those non-exempt employees who are telecommuting, or they call it teleworking, and presumably not affected by the closing of the employer's work facility, employers, since they are working, they're non-exempt, have an obligation to pay time and 1/2 the regular rate of pay for overtime hours. How about the exempt employees? Well, what's the general rule as it relates to these salaried employees? And as you know, the Department of Labor has put out very extensive proposed regulations dealing with these definitions. Under the statute, employers are for the most part obligated to pay exempt salaried employees their full salary in any week in which they perform any work, and are not required to pay exempt salaried employees in weeks in which they do not perform any work. So that's a second piece of legislation. Again, there are myriad questions that can arise under all these statutes. I'm primarily a tax practitioner, so I'm in love with statutes, and the labor area is filled with them. Let's take a look at one more statute, and I might contradict the answer to the second question. The Family and Medical Leave Act that was enacted during the first Clinton administration in 1993. So let's take a look at question number 1, which is rather short. The legislation does not protect employees who seek leave to avoid exposure to influenza. Now, certainly that's something that I don't blame an employee wanting to stay home, not be exposed to his fellow employees. So he may think that the federal Federal Family and Medical Leave Act would allow him to do so, but that is not the case, simply to avoid exposure to influenza. Let's take a look at another question that, based on the Families First Coronavirus Response Act that the House signed off on March 14th, the Senate and the President signed off on March 18th, and became effective 15 days later, that is to say, April 2nd, coming up. So we haven't reached it. Federal law does not require, and this was the way the legislation was before the enactment just during this month. Federal law does not require that paid leave be provided to employees who are not at work because of illness attributable to pandemic influenza, or have had exposure to a person suffering from such illness, or attending family members affected by the disease. That's no longer true, because with the Families First Coronavirus Response Act, which is divided, I think, roughly into 7 divisions. The divisions you might want to look at would be Division C as in Charlie, that deals with the Emergency Family Medical Leave Act, Expanded Act, and also deals with the Emergency Paid Sick Leave Act. Taking a look at the Paid Sick Leave Act, it's good for 2 weeks. covers 80 hours, unless you're a part-time employee, in which case a computation may have to be made to determine the number of hours to take into account for a part-time employee. During those 80 hours, you will get paid your full pay, but not to exceed $511 per day, which would give you $5,110 for the 2 weeks. On the other hand, a part-time person, and there are 6 possibilities that might apply here under the possibilities 4 through 6 that don't deal directly with the employee who may be sick himself, then the maximum pay is 2/3 of the regular pay, not to exceed $200 per day. Now, what's interesting on the Family Medical Leave Act, under the original legislation in 1993, it didn't apply unless the employer had 50 employees. This legislation applies if you have under 500 employees. On the theory, I would suppose that large employers already have many of these provisions in place. If in fact you have under 25 employees and having to pay this sick pay or Family Medical Leave Act pay threatens your viability as an ongoing concern, you may seek exemption. What's interesting is the employer can elect to exclude, because they probably want them working, healthcare providers as well as employees who are emergency responders. Finally, on the last division that I choose to cover very briefly is the one dealing with payroll taxes. The employer will not have to pay the employer's share of payroll taxes. The amount of pay for the sick pay and the amount of pay for the family and medical leave will offset the liability for the employer's share of payroll taxes. Any excess amount can also be refunded to the employer. I should mention that this legislation expires on December 31st, 2020. In any event, thank you for your kind attention, and we look further to find out the many details of this legislation, as well as the stimulus package of $2 million that have been agreed upon by the Senate and the executive branch. Thank you very much.